Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show. Hello, and welcome to a special edition of Our Curious Amalgam. I'm Alicia Downey. The annual spring meeting of the ABA Antitrust Law Section is the premier event of the antitrust and consumer protection world. At the 2023 meeting, the Our Curious Amalgam team recorded interviews with more than a dozen leaders of competition agencies from all over the world. We asked each of them about their current enforcement priorities, what enforcement trends they see on the horizon, and tips for practitioners representing parties under investigation. We also got to know our guests a little bit better on a personal level. The title of today's episode is, Who is Willard Mwemba? A conversation with the Chief Executive Officer of the COMESA Competition Commission. Willard Mwemba has been an important competition law enforcer in the African region for over a decade. In addition to leading the Competition Commission for the Common Market for Eastern and Southern Africa, also known as COMESA, he has played and continues to play a key role in the development of competition and consumer protection laws, guidelines, and operational manuals in COMESA's member states. As you'll hear from Sergei Zaslavsky's interview, recorded live in Washington, D.C., Dr. Mwemba is also a scholar of antitrust and competition law. Let's hear what he had to say at the 2023 spring meeting.
Hi, this is Sergei Zaslavsky, and I'm talking to Dr. Willard Mwemba, Director and Chief Executive Officer of the COMESA Competition Commission. COMESA is the Common Market for Eastern and Southern Africa, a regional economic community comprised of 21 member nations. The COMESA Competition Commission is an agency formed in 2013 that is responsible for enforcing the COMESA regional competition law framework. Dr. Mwemba has been with the COMESA Competition Commission since its founding and has headed the commission since November 2021. Welcome to the program, Dr. Mwemba.
Thank you for having me, Sergei.
Why don't you tell our listeners, what is your top enforcement priority for next year?
Yeah. Before I address your question, I would love to tell my listeners something that is a bit misleading in the term COMESA, as you rightly said, Common Market for Eastern and Southern Africa. So for those who've never heard about COMESA, they would be misled to think it only involves Eastern and Southern African countries. But to the contrary, it also involves North African countries. And the North African countries are just as much in number as the East African countries. So we have Libya, we have Egypt, we have Tunisia, we have Sudan. So those are not in East and Southern Africa. They are in the northern part of Africa, but they are very much members of COMESA. So maybe, Sergei, we should in future maybe be thinking of amending the the term COMESA. Who knows? Now, what are the top enforcement priorities for next year? It is very clear that since inception, we have focused more on measures. So when we commenced the COMESA Competition Commission operations in January 2013, up to somewhere in about 2016, most of our focus was on mergers and acquisitions. And then around 2016, we changed focus somehow. And you agree with me that for a nascent competition authority, obviously, as you are trying to establish yourself, as you are trying to make yourself known to the stakeholders and those would be subject to your law, mergers and acquisitions becomes a very easy area to enforce before you establish yourself and find your feet. So by 2016, 3 years later, our focus had changed to what we call restrictive business practices or anti-competitive agreements, slightly short of being cartels. Okay, so these are horizontal and vertical agreements that became most of our focus, and we've done also quite a lot of work in that area, dealing with very big companies, Coca-Cola, Unilever, the Confederation of African Football, and a number of other big companies that were engaged in agreements that we considered incompatible with the COMESA competition regulations that we enforce. And then you also want to understand that we have dual roles, not just competition, but also consumer protection. So from 2016 to 2019, somewhere there, our focus on was on these agreements I've just told you. But 2019, again, we shift focus to another interesting field, which is consumer protection. And between 2019 and to date, we've also done quite a good number of consumer cases. The recent one that comes to my mind involves Jumia. Jumia is an online selling platform, equivalent to platforms like eBay and Amazon. So Jumia engaged in some conduct that violated, in our view, consumer rights, several conduct in their terms and conditions that violated consumer rights. So it's one of the biggest cases that we dealt with, and we're glad to report here that they were very cooperative. They complied with what we wanted them to do to change their ways. Now, after this long story, I address your question now. What is the focus for next year? In fact, that focus has started this year. Our focus now has shifted to cartels, hardcore cartels. And why the focus now? I'll tell you why. As I said when I just began, when you're a new competition authority, obviously the first thing you would want to do is to investigate a cartel. Cartels are quite difficult to investigate. Businesses of this century or this generation are more sophisticated than the businesses of yesteryears. So you really need to have proper enforcement tools. You really need to understand your law. You really need to have good skills. You need to have good human and financial resources to do that. So it would have been very erroneous of us, if I may use that term, to immediately in 2013 to have wanted to tackle cartels. And remember, once you fail, we shouldn't be fearful of failing. But sometimes once you fail when you're just beginning, it may not be a good sign, and probably it may project your failure in the coming years. So we're very careful about that. But we now think we've reached a stage in our life as COMESA Competition Commission where we have the tools, where we have the skills, where we have the human and financial resource and capacity. But also remember, we are a multi-state competition authority, so we enforce competition law on matters that involve 2 or more member states, and we have 21 member states. We've also reached a stage where we've helped strengthen national competition authorities in our 21 member states, and we work very closely with those national competition authorities. So when we are investigating cartels, detecting cartels, the national competition authorities become our tentacles, because our law also allows them, it gives them investigative powers and searching powers in their jurisdiction. So they understand our law very well now. They've been capacity building on the enforcement of our law. They understand, not only understanding our law, but also our role in terms of defeating these cartels. So that is the next stage. Now we think we are ready. And then secondly, one thing that is motivating us to do that is that we believe there is so much poverty in most of our member states. There's so much poverty, and one of the practices or conduct that exacerbates poverty are business conduct. Cartels, those that rob our governments millions of dollars, those dollars that could be used in schools, that could be used to build good roads, that could be used to buy good medicines and stuff like that. So we want to contribute now to this very evident, very visible, very tangible cause that we are contributing to the reduction of poverty in our member states and on the continent generally. So our focus beginning now and most of next year going forward is to detect, investigate, prosecute, and fine cartels.
Very interesting. And certainly, as you note, one of the things that I'm sure motivates you and other competition enforcers is policies, enforcement priorities that can make a tangible difference in people's lives, fighting poverty, as you say. One of the interesting things about cartels under American law is that unlike a lot of other types of antitrust violations, cartels can be prosecuted criminally as well as civilly. Is that the case in COMESA as well?
That's a very interesting question. So in COMESA, no. At COMESA level, a prosecution of cartels, we only do civil proceedings against that. But in our member states, in some of our member states, it's actually a criminal matter. I know Zambia is criminal, Kenya, it is criminal, Egypt is criminal. So in individual member states, this is criminal. But at COMESA level, it's civil. And just for purposes of clarity, I know sometimes I've observed that sometimes we have different understandings of what you mean by civil and what you mean by criminal. I recall I was at an enforcers meeting here in Washington on Monday, and someone was talking about cartels being criminal, but they were talking about them being fined. Now, in our jurisdiction, when a fine is imposed for an offense, and only a fine, if the law, the statute talks only about a fine, then we call that a civil proceeding. And where there is a custodial sentence, if someone can be sent to jail, those offenses we categorize as criminal. So I just wanted to make that very clear. I know our audience is coming from different parts of the world, so we have to be on the same table. At COMESA level, it's only civil, so we only fine you. But remember, we only deal with a cartel that affects 2 or more countries. So what happens is, if that cartel affects 2 or more countries, then I would reluctantly say those companies that are involved in that cartel that involves more than 2 or more countries are lucky, because they'll only be subject to fines and will not be subject to further prosecution at national level for avoidance of double jeopardy. Okay, so we can't prosecute them at COMESA level and then they are prosecuted individually in the member states for avoidance of double jeopardy. And then also, look, if we want the COMESA system to work in terms of detecting these cartels, once the COMESA Competition Commission acts on this cartel and these guys are subject to individual prosecution at member state level, it will be very difficult for us to detect those, because then we discourage probably the whistleblowers, lenient applicants and everything, because they know prosecution at COMESA would not end the story. They may be actually be sent to jail at national level. So I think the people who crafted the COMESA competition regulations had that in mind, that at regional level, for cases that violate competition laws in terms of cartels at regional level, let's leave it at civil liability, and then at national level, meaning if it doesn't spill into other countries, they can go as much as they want. I believe that could be the arrangement in the European Union. I believe the European Commission does not impose criminal sanctions when it comes to cartels, but fines. Someone may correct me on that. But the slight difference is, if I recall well, is that in the EU, I think nothing stops the member states in such circumstances to impose even greater sanctions. But obviously the focus is on COMESA. So for us to again answer your question directly, we treat cartel offense in civil proceedings.
Certainly interesting added layer of complexity between the interaction of the regional law and then the national law.
Absolutely.
Very interesting.
Absolutely.
So you gave our listeners a great overview of the history of the COMESA Competition Commission and your present focus. Let's now shift a little bit and gaze into the future. What do you see as the most important trends in competition and consumer protection law that are relevant to COMESA?
I'll start with competition. probably even consumer, it will be the same, except one will be on the competition side, the other one on the consumer side. But I think the biggest which I would also call the biggest challenge that we think we are beginning to face and will face more in the future is how to deal with violations in the digital economy. We have seen lots of sophistication in that sector. It is a very fast evolving sector, and that most competition authorities, I believe, not just COMESA, are having to play catch up. That things are moving so fast, technology is moving so fast, and we're having to play catch up. So I think that would be the most important and most challenging matter, in that how do we keep up the pace instead of always being a step or two behind, and by the time we are catching up, the effects are there on the market. Startups have already been swallowed or eaten up by the time we are realizing what is happening. I think to us, those are some of the most important issues, especially that we are dealing with economies that are very, very small. We are dealing with economies that are very concentrated. I'll give you something that I hate to talk about, I even hate to think about. But you see, we have certain big tech companies that whose turnover is probably much bigger than the GDP of the entire COMESA. Okay, that is very scary. So how do we deal with those companies? Some of them would behave with impunity, that look, if you are telling us that what we are doing is wrong, you probably are becoming an unnecessary rigidity to our operations in your market. We don't make much money in your market after all. We can easily leave. There are those threats, and these things are real. I'll be very careful not to mention the company. I'll be very careful, but I'll mention it because it was in public domain. You remember what had happened in a big country, big economy, developed and advanced jurisdiction like Australia, when the Australian authorities were concerned with the conduct of Google. Remember, Google had threatened to stop operating in Australia. There was an issue of also, I don't know if it was Facebook or Twitter, but similar issues in Nigeria, where of course, the Nigerian situation could have been different, but I'm just trying to talk about the possible reactions in Nigeria, where they also threatened to pull out. So, do we have that impetus? Do we have that courage? Do we have that strength to tackle these big tech companies head on when they engage in anti-competitive practices in our jurisdictions? Do we have the skill to prove those cases? Because I know even here in the United States, which is a very advanced jurisdiction, especially when it comes to the enforcement of antitrust laws, it has not been easy to deal with some of these big tech companies. So to me, Sergei, those are some of the issues that are giving me sleepless nights to ensure that we are equal to the task and dealing with these companies. Similarly, on the consumer side, we've seen a fast evolving digital consumer world, especially at the advent of the COVID-19 pandemic and after. We have seen so much technology developing in this field that most consumers now would need to have a basic understanding of technology to deal or to transact in markets. But something that is so worrying to me is that most of our consumers do not have that basic knowledge. And as a result of that, they are subject, unfortunately, to abuse, which they will not even understand that they've been abused. How do we make sure that our consumers understand these matters? How do we make sure that our consumers are equipped with the knowledge and the skills to transact in this highly digitalized world? It's a tall order because we are not only looking at enforcing the law in terms of prosecuting those that have violated it, but we are also looking at ensuring that the consumers understand even before the violation takes place, because maybe the violation itself may be prevented by the consumer knowledge itself. So that gives me a lot of sleepless nights, and we have started raising awareness to consumers, but we have a diverse population. The geographical coverage of the COMESA is 12.5 million square kilometers. It's quite huge. The population is about 580 million people. And if you are talking about cross-border matters, we only have this Competition Commission with 35 staff members in Malawi. So how do we quickly spread that news? How do we quickly ensure that everyone is on board? It gives me sleepless nights, but I'm glad to report that we are working closely with all these national competition authorities in those 21 member states to ensure that we are tackling these things in real time.
Yeah, certainly a challenge that you see all across the world with the rapid pace of technological changes. Enforcers have a lot of new issues to think about.
Yeah.
Shifting gears a little bit, I'm sure you have seen a lot of lawyers advocate in front of your agency. Probably some do a good job of it and some do not such a good job. What advice would you give to an advocate who comes in front of your agency? How can they advocate effectively?
Yeah. The first point I would love to give them, which is a point I've stated almost everywhere where I've spoken, is that our role as the COMESA Competition Commission is not to frustrate business, but to facilitate business. What do I mean? Our role is not, our focus or intention is not penalization, but remediation. So we are not interested in punishing business. We are not interested in fining. Fining to us will be the last resort, probably in, especially in cartel cases. There's no two way about it. But in other issues, most of the times we've sat down with businesses, tell them to amend their ways, and if they are compliant and they are cooperative, commitments work with us. So that is the first thing I wanted to say. The second thing, what I would be telling them is that, look, there is no reason in trying to bring arguments that result in evading the law. You only make it worse. There are reasons. You have all the reasons to come and approach us in a transparent way. State things as they are. We work together the solution in the interest of themselves, in the interest of the commission, in that we will not waste time and we'll focus our resources on other issues, but also in the interest of our markets. It's very, very important. And why I would be telling them to do that is clearly because our intention is not to fine them. So in that situation where we see that they cooperate, it's very unlikely that we'll even fine them. It is very likely, and we've demonstrated this in the past, that we will come to a solution that simply removes the anti-competitive conduct on the market while leaving them to operate as free as they can be without any fine. Fines, of course, will only come in now when they are being very opaque, when they are hiding information, when they are being manipulative. You know, sometimes lawyers, and I've seen this, sometimes they are manipulative. I was just talking to a lawyer colleague, I'll not mention the law firm, but one of the biggest law firms in Africa, just now, and she was telling me, I saw the letter that you sent to us. And I knew that when you were writing that letter, probably you were angry. And I told her, yes, I was angry because, look, their argument was we think this transaction is not notifiable, and they bring in robotic arguments of who is the parent and who is a subsidiary. And when I was writing, I told her, yes, I was angry because I was writing saying that, please, let's not waste time. These principles of subsidiary, parent company and everything are common knowledge to every lawyer who thinks they are a lawyer. So those are some of the things I'm talking about, that let's not be manipulative. The more you waste the authority's time, the more probably the authority thinks of giving you a lesson to avoid such offenses, to avoid recidivism in principle. So that's what I'll be telling the lawyers. I'll be telling them, let's be transparent with each other. Our focus should be to help the markets, not to punish you, but punishment will come when you're being manipulative, when you're being you're not being transparent. Definitely there. If we come and establish a case and you've done all these things, that will be taken into account as to the decision that we make, and fine definitely will come.
Sounds like a cooperative mindset rather than an adversarial mindset.
Absolutely.
Would be advisable for somebody advocating before your agency.
Absolutely.
A final question here. On this program, we like to get to know our guests as people, not just as professionals. With that in mind, can you tell our listeners what are some of the interesting hobbies or accomplishments you have outside of the competition and consumer protection area?
It's a good question, and my answer, Sergei, is that most people think I'm an extrovert. Most people think I'm very outspoken, but the truth of the matter is that I'm actually very boring because frankly, I don't have a hobby in the context of hobbies that people talk about. For example, people talk about listening to music. People talk about I like playing or watching soccer. I like swimming, things like those. And I have none of those, and I think I'm very boring when it comes to that aspect. But if we are to call it a hobby, the thing that I do most of the times is reading. I read and read and read, and the reading that I do is antitrust law from the time I got in love with this subject in 2005. So I read and read and read and read antitrust law without ever getting bored. And then of course the other thing that I read so much is the Bible. I'm a Christian, quite a devoted but liberal Christian, if I may use that term. So if we can call those hobbies, those are my hobbies, Sergei.
Well, I can certainly relate to being an antitrust nerd. I can't get enough of the antitrust press as well.
Yeah.
Well, it's been great having you on the program. Thank you so much for joining us.
Thank you so much for having me. Take care.
That's all for this episode. Thank you to my co-host, Sergei Zaslavsky, and our distinguished guest, Willard Mwemba. We're featuring interviews with many other international enforcers in past and future episodes of Our Curious Amalgam. So if you're curious about what they have to say, listen and subscribe wherever you get your podcasts.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.